Namaskar and welcome to StudyIQ. I am your friend Rahul. The agenda for today's discussion is connected to Indian polity, and I would say our topic for the day is quite cliched. We are going to discuss about the office of the governor. The gubernatorial office has been embroiled in controversy often, I would say since 1967 largely. Now you're thinking, sir, why 1967? Before that year, it was Congress system in India. That means at the center level, there was Congress government. In states, largely, there were Congress governments, and there was seldom any issue of center-state tussle. However, since 1967, with the emergence of non-Congress governments and later on in the coalition era, we have seen the office of the governor embroiled in controversies regularly, and it's back in news again. You can see here, recently, the apex court has asked the question, what was the governor of Tamil Nadu doing for 3 years in a recent case? In this video lecture, we are going to understand this entire issue. And I would say our discussion is largely connected to Article 200, which deals with the governor's powers of assenting the bills passed by state legislative assembly. This is going to be a very important discussion from exam perspective, both for UPSC preliminary examination as well as mains examination. So give keen attention to this video lecture and collect all the information which is very, very relevant from exam perspective. All right, let's begin. But before that, to all the UPSC civil services aspirants, there is a small notice. StudyIQ's P2I batch number 4 is going to begin on different dates. We have 3 formats: English, Hindi, and a bilingual format. The English batch is going to start from 24th November. This is going to be 8 a.m. batch. Now you do understand that StudyIQ's motto is to take education to nooks and corners of the country at affordable price. The entire UPSC preparation package has been designed at this price, heavily discounted price. Now this contains everything: one-to-one mentorship, group mentorship, prelims test series, mains residential program. The whole shebang comes in this price. Just visit our website www.studyiq.com, enroll now. I'll see you in the class. All right, let's begin our discussion about the office of the governor. As I mentioned, this gubernatorial office has been in controversy regularly. Now, from UPSC perspective, this is one of the favorite topics for them as well. Many a times questions have appeared in preliminary examination, in mains as well. Now, the general theme of questions that we have seen with respect to office of the governor, I would say they are, or they can be categorized under 3 different topics. First, the issue of governors, especially with respect to appointment. Now, we have seen that there is no specific qualification for appointing a governor. Now, what happens here is, generally, the ruling party, the central government ruling party, they appoint their loyal people as governors in different states. And we have seen that since the beginning of non-Congress system, the coalition era, we have seen at the center level, there is one particular party which is ruling, and at the state level, if the party is different, we have seen a lot of tussle between center and states. One, with respect to the appointment of the governor. Second one, with respect to appointment of, the removal of the governor. Now, you do understand, in the constitution, there is no procedure for removal of the governor or transfer of the governor. And arbitrarily, they have been removed. So, appointment and removal is a major issue with respect to the governors. And then the third theme would be with respect to the working of the governors in different states, especially in the states which do not have the same party as the ruling party in the center. Now, when you talk about the working of the governor, the first aspect which is connected is to Article 163. Now, this Article 163, it deals with the discretionary powers of the governor. Indian Constitution, it gives extraordinary discretion to the governors. Now, that is why we say the President of the India, who is the executive head for the central government at the central level, they do not have heavy discretionary powers. But the governors at different states, they have been given more discretionary powers. In fact, under Article 163, subclause 2, the discretion or the decision regarding the discretion of the governor, that is also the power of governor themselves. This is one of the issues. Apart from that, evergreen issue of Article 356 is there. Now, before 1994, I would say Article 356 was largely a weapon in the hands of the central government or weapons in the hands of the governor. the governor's adverse report, it led to president's rule in different states. And many a times elected governments were dismissed. However, since 1994, this issue has largely subsided, especially because of the S.R. Bommai judgment, after which we have seen sparse use of this power by the governors. But still, it is there. The power still remains. It is quite controversial. And there is another aspect which is connected to Article 200, through which the governors control the state legislature. And I would say today's discussion is about Article 200, and we can club that with Article 163 as well, so that using the discretionary powers, the governors are somehow holding the state legislative behind, or holding the powers of state legislative assembly at stake, right? That's the basic discussion. But why I discuss this entire part is I would appreciate if all the UPSC civil services aspirants, from the governor's point of view, make a note of these issues along with the changes, the recommendations that are sought in the office of the governor. Today's discussion, you will get very good content regarding these. All right. That's why I told you important information both for prelims as well as mains. Now let's come back to the news. As I told you, there is a case which is pending in the Supreme Court. The case has been filed by the state of Tamil Nadu, in which they have asked questions regarding the actions of the governor R.N. Ravi, over which the Supreme Court has asked, what was the governor doing for past 3 years? There were numerous bills which were passed by the state legislative assembly where the governor did not take any action. Now let me give you some insight into what exactly happened. Now you do understand that Tamil Nadu, the state is governed currently by DMK. That means a party which is not the same at the center level. So through the governor, many state legislative assembly bills were held, or I would say not withheld per se, but they were simply put in a black hole. There was no decision which was made on them for a very long time. That's why the question was raised. Now you are thinking, sir, what exactly happened? Let's go to the background. The Tamil Nadu government, the DMK government led by MK Stalin, they have repeatedly been at loggerheads with the governor R.N. Ravi. In fact, they have made statements where they have said, sack Tamil Nadu governor who is sitting on many bills and questioning the state legislature. Stalin and the governor have been at loggerheads over multiple bills. It may be connected with the need bill, it may be connected with the powers of the chancellors, it may be connected with many other different bills, over which the ministers, they had boycotted Raj Bhavan event in 2022. In fact, the Tamil Nadu government had also written a complaint to the President of India regarding the governor. They had called the governor unfit, who had been sitting on more than a dozen bills for a very, very long time. They were duly passed by the state legislative assembly. So this was the issue. And finally, a couple of months back, the Tamil Nadu government ultimately reached the Supreme Court and filed a plaint or filed a writ petition through an individual against the governor. Now you are thinking, sir, how is this possible? Under Article 361, I already know that the office of the governor and the office of the president are immune from any sort of criminal action. Of course, any sort of civil action as well. Civil action can be initiated, but with a due notice of 2 months. That is the protection provided for president and the governors. Now you need to understand why I mentioned that in a very common lingo was because you will see in many articles that Tamil Nadu files a complaint against the governor, Tamil Nadu files a case against the governor. A case cannot be filed against a governor without a due notice. Criminal action cannot be taken, of course, you know. But here, the case is against the Principal Secretary Office of the Governor. Clear? When I say against the governor, that is not exactly against, it's not like state of Tamil Nadu versus R.N. Ravi. You need to understand, it's one individual. Right now, it is a writ petition which has been filed by an individual where the respondents are the Principal Secretary of the Office of the Governor, Tamil Nadu, the Chief Secretary of Tamil Nadu, and also the Law Ministry at the center level. So these are the respondents. That's why they are all party to the case. Clear? Now this is a technical doubt which many aspirants ask. Now what exactly is the bone of contention here? The bone of contention is Article 200. Now Article 200, it gives powers to assent the bill to the governor. Now when you go through the details of this particular article, you will basically find you will basically find a structure something like this. When a bill is duly passed by the state legislative assembly, if it is a unicameral house, it's passed in the Vidhan Sabha and sent to the governor for assent. If it is a bicameral house, it is passed through the Vidhan Sabha, Vidhan Parishad, and then sent to the governor for assenting. When the bill duly passed by the state legislative assembly, it goes to the governor. The governor has 4 options according to Article 200 itself, this article. Now, what are the options? Fair and square, simply say yes, then the bill becomes an act, right? The governor says, no, I am not going to pass this bill, then that ends. The third option is return the bill to state legislature, for reconsideration. Then there is another 4th option under Article 201 for reservation to the president. That means governor can reserve the bill for presidential recommendation. And once the bill is reserved for presidential recommendation, the governor is completely bypassed. Now here, the president has the power either to assent the bill or to withhold the assent. All right? Or he can also tell the governor to return the bill for state assembly for state reconsideration, provided it is not a money bill. And here there is a very interesting clause. Now, whenever it goes to the president and president has sent it back to the house for reconsideration, the house must consider the bill within 6 months from the date of receipt of such message from the presidential office. Now, why I am highlighting this is there is a very good technical catch here. Okay. Now, after looking at this, you understood, okay, sir, everything looks fair and square because very similar powers are also given to the President of India. So I don't find any controversy here. What is the major issue now? The major issue is in the wordings of Article 200. It suggests that the governor shall assent or do whatever action he takes as soon as possible. That means there is no time limit which has been mentioned. And it is because of this that the governors have been using the pocket veto indiscriminately. That means a bill which has been passed by the state legislative assembly duly through the procedure, it reaches to the governor's office and the governor is not doing anything because there is no time limit mentioned in the Indian Constitution. Remember, strangely, for the president, that means when the president sends it to the state legislative assembly, they have to reconsider it within 6 months. But the president does not have any duty to consider it within a due time. So president and the governor, they do not have any sort of time limit within which they have to decide over these bills or decide over the advice of the Council of Ministers. Very interesting, isn't it? That means both the governor and the president of India, they have pocket veto. Now, here we are discussing about governor specifically. And governors in states like Tamil Nadu, they have been misusing this power. Now, what has happened in the current case of Tamil Nadu? The case has reached the apex court and the Supreme Court, it went through all the information, all the data, and it observed that since 2020, the office of the Tamil Nadu governor, they have received more than 180 bills, out of which they have said, yes, they have assented to 150 plus bills. However, more than 20 bills were held pending variously from 2020, 2021, 2022. In the last three and a half years, there are so many bills which are pending with the office of the governor, Tamil Nadu. Now, when question was raised to the Attorney General, what is the governor doing? There were some excuses which were given. In fact, during the case itself, the Supreme Court had asked a question to the Principal Secretary Office of the Governor, what is the governor doing? And this question was asked on November 10, 2023. And after that, as soon as Supreme Court intervened, the governor's office from Tamil Nadu, they returned back 10 bills to the House, and they said, I am withholding the assent, that I am not passing these bills which were sent to me by State Legislative Assembly. And many of these bills, they were passed in 2020, 2021, 2022. For almost three and a half years, there was no action which was taken. That means no yes, no rejection, simply sitting on the bills. As soon as Supreme Court intervened, within 3 days, the office cleared 10 bills where they said, no, I am not passing these bills. So these were the details that were given. 5 of the bills were withdrawn by the government itself. There were 9 bills which were reserved for presidential recommendation. 10 bills, they were withheld on November 13, and the Attorney General basically gave information that currently there are only 5 bills which are pending with the governor of Tamil Nadu, that too from October 2023. There was also one more excuse given, that the current governor, he has taken office, or he is the incumbent from November 2021. So there is no case about 2020 bills. But the Supreme Court wrapped the council, and they asked the question to the office of the governor, that what was the governor doing for 3 years? Now we are not talking about one individual, but we are talking about the office of the governor. All right. Now this was the question raised by the Supreme Court. Now what happened after the governor of Tamil Nadu? He said, I am withholding the assent to 10 bills. What the Tamil Nadu State Legislative Assembly did, they convened a special session, and in that special session, they repassed all the 10 bills and they have sent it again to the governor for assenting. Now you do understand there is a catch, right? There is a small difference between the powers of the governor and president. Now, if we look at Article 74 closely, under Article 74, because of the 42nd Constitutional Amendment Act and later on the 44th Constitutional Amendment Act, the president is bound to say yes to the advice of Council of Ministers if it is resent again. Such clauses are not available for the governor. I hope you understand the nuances between powers of president and the governor. The president can resend the advice of the Council of Ministers once, but if the Council of Ministers, they give same advice to the president, then the president shall be bound to accept it. The question is, what will the governor do now? And the ball is in the court of governor again, right? The Supreme Court, in the latest hearing, they have suggested that the governor cannot sit on the repassed bills. And everybody is now watching at the office of the governor. Will these 10 bills be given assent, or will they be withheld? And the hearing on this particular matter is on December 1st, and we will be keeping a keen eye on these proceedings. I hope you have understood the entire issue. The issue is bills being passed by the elected house, and an appointed individual or the office of appointed person, they are holding on to these bills. Is it happening only in Tamil Nadu? No. It's happening in many different states. Earlier as well, state of Punjab, it reached the apex court. State of Kerala had sought intervention. State of Telangana had also sought intervention from the apex court regarding this matter. Now you are thinking, sir, this looks a very controversial issue in Indian political system. What can be done here? If you look at the Constituent Assembly debates, people had highlighted that under Article 200, there must be some sort of time limit. For instance, Professor Shibbanlal Saxena in the Constituent Assembly, he highlighted that the governor should dispose of these matters within certain time limit. And there was a huge debate over that. Ultimately, it was envisaged that the governor's office, they are going to act as check and balance on the hasty legislations by the State Legislative Assembly. That is why there is no time limit mentioned. In fact, T.T. Krishnamachari had enunciated here that the role of governor is envisaged on a similar fashion or a similar trait as the presidential office. That means the governor is bound by the aid and advice of the Council of Ministers. They shall not go against the Council of Ministers, and there must be harmony between the legislature and the executive, that is governor and the Council of Ministers. But this is seldom seen. Now question comes up, sir, what can be done? Are there any recommendations, right? See, first of all, its constitutionality was questioned in the courts way before. In one of the cases, Purushottam versus Nambudiri versus State of Kerala in 1962 itself, Supreme Court had suggested that we cannot prescribe a time limit because Constitution does not impose a time limit. But what we observe is, according to the constitutional morality, according to constitutional norms, the governor must honor the will of the legislature and must act in harmony with the Council of Ministers. That is what Indian Constitution envisages. It envisages accountability, responsibility, not tussle between ministers and the executive, or not tussle among the executive itself, right? That is what has been dreamt by the forefathers, the Constituent Assembly members. But some recommendations, especially Sarkaria Commission in 1985, they had recommended that to bring harmony between the Council of Ministers and governors, whenever a bill is being introduced, the office of the governor must be taken into cognizance. They suggested that prior consultation can be conducted with the governor's office and a time limit for its disposal can be discussed beforehand. The NCRWC, National Commission for Review of Working of the Constitution, in 2002, not 2022, 2002, it had recommended that there should be a time limit, and this time limit was not suggested, but they simply said something like 6 months can be a time limit within which the governor must dispose of these bills or whatever is the advice which is coming from the Council of Ministers. Now you're thinking, sir, what is wrong? What is wrong? The Constitution has envisaged that there shall be a pocket veto to the governor. What is such a big deal? See, first of all, if the governor is simply sitting on the bills, if the governor is not taking any decision on the advice of the Council of Ministers, it amounts to violation of rule of law, violation of Constitution as well. It ultimately leads to policy paralysis and policy delay. Imagine a very important bill which was passed by State Legislative Assembly and the governor is not taking any action on it. Who is the ultimate sufferer? We are the ultimate sufferer. People are the ultimate sufferers. It also leads to constant tussle between center and states because the governor, I wouldn't call it governor as the agent of the center, but a connecting link between center and state. So if there is a tussle between governor and the states, it leads to center-state relations, more and more tensions. And finally, it leads to erosion of public faith. Public's trust from the administration would be slowly and steadily eroding. You think that I have elected these representatives, they are supposed to bring good laws for me, they are supposed to bring good policies, they are supposed to give me services, but ultimately because of their own bickering and tussle, nothing is happening. So people slowly and steadily start losing faith in the public administration. So it's a very, very important issue which needs to be addressed. And I would say ultimately the ball is now in the court of Governor's office in Tamil Nadu, and the ball is also in the court of Supreme Court. Let's see if they will prescribe some sort of a limit, and if it does happen, then we might expect, say, a constitutional amendment through which Article 200, Article 201 and other articles would be amended for providing certain time limit, right? Let me conclude my discussion by asking one more question, or whatever question you have in mind. You're thinking, sir, president has the pocket veto, why should governor not have it, right? So what can be done is, even for the presidential office and the governor's office, there can be a time limit, common time limit within which they have to dispose of these pending bills. If you ask about president, the presidential office and the presidential decisions were also questioned. If you remember the Shatrughan Chauhan case, the same thing happened. The president was sitting on so many pending mercy petitions. Ultimately, the Supreme Court intervened and it said that if the president is not deciding the mercy petitions within a due time, it amounts to mental torture. And it also gives a right to the convict of commutation. That means a death sentence, death penalty can be commuted to life imprisonment. That was held in the Shatrughan Chauhan case. So it's not just the governor's office, but the issue is there with the presidential office as well. So if you have this question, probably a time limit can come for both the offices to dispose of the files, dispose of the pending bills in front of them, dispose of the advice given by the Council of Ministers as soon as possible within the limit that is defined or that must be defined. All right, that's the basic idea. Clear? So I hope through this discussion you have gotten a good insight into the controversial nature of the working of the office of the governor. If there is any update on this, we'll be having a keen eye on December 1. Whenever judgment comes, whenever development comes, we'll have an interaction again on Study IQ. Thank you for watching this video. We'll meet soon in the next session. Jai Hind.